Hello, uh, welcome to this channel. I hope you are all fine. And if you are new to this channel, first I want to give some introduction about this initiative. My aim is to complete the current affairs for your exams, which are going to be held in 2024, whether it is UPSC or PSC exams, state civil service exams. I would try to complete them before the prelims, mainly in the month of April. I would try to complete this series. Currently, I am discussing here the current affairs from last 1 year regarding polity and governance. After this, I would take up international affairs, then economics, then ecology and environment, science and tech, and security. These would be the main 4 to 5 subjects which would be discussed here. Then, if time permits, I would take up other important schemes or important personalities, important places which were in the news. Mostly that would come under this series only, but if time permits and I would miss some, I would take them up. So, without wasting any time, let's jump to our main topics. It is regarding electoral funding. If you are aware right now, if you are aware about the news, you might had heard or read that electoral bonds, their time has ended. They are discarded. Now, this PPT is almost 2 to 4 months old. So let's see what was then in the news. That time Supreme Court directed Election Commission of India to submit data on the electoral bonds received by political parties. If you remember, same order was given to State Bank of India to by Election Commission to reveal the money they had received via electoral bonds and the name of the people, name of the parties, and they recently submitted that. So here in this topic, Supreme Court directed Election Commission of India to submit data on the electoral bonds received by political parties. Regarding this in 2019, while hearing the important petition filed by Association for Democratic Reforms (ADR) against the electoral bond scheme, that SC Supreme Court asked the Election Commission of India to submit data on electoral bonds. So, Election Commission of India received status report from 105 parties regarding that. State Bank of India has received that only 25 has revealed that only 25 political parties had opened the bank accounts necessary to receive electoral bonds. So, before going to next slide, let's recap this what was in this. Let's try to recap this information present in this slide. Here it is simply the introduction of the topic, where Supreme Court then asked Election Commission of India to submit the data on the electoral bonds received by political parties. While hearing the petition filed by Association for Democratic Reforms, that electoral bond scheme that SC asked about against the electoral bond scheme, in which SC asked the Election Commission of India to submit data on electoral bonds. In this context, ECI received status report from 105 parties, and SBI, which is the bank which was designated to issue electoral bonds, what they revealed that only 25 political parties have opened the bank account necessary to receive electoral bonds. Let's go to the slide. Now, what was the status of electoral bonds? If we see, according to the data collected by ADR, 69% of the total income of political parties during 11-year period between financial year 2004 to 2005 and 2014 to 15 was from unknown sources. And similarly, sources of income of national parties for financial year 2021 and 22, if we would see that as per annual audit report, it is 66% approximately, which is from unknown sources, and donation donation details declared to ECI that income from unknown sources is 23%. So here we have little bit states about electoral bonds which were issued from different years, and what was the status of funding in political parties since 2004 to 2015. In these 11 years, almost 69% is from unknown sources. So here arises a question, right to information. This is one of that citizens should know who is paying the political party, how much they are paying. This these things should be known to the voters. So here arises the question of right to information. So what were the, if you know that these electoral fundings or electoral bonds, what are the concerns regarding them? Here we are not specifically discussing electoral bonds, we are discussing overall the electoral funding here. Let us see what are the concerns related to that. As I had mentioned here, I had divided it in four major topics. Let us see what they are. First one is huge expenditure. If you know that in Lok Sabha election in Lok Sabha 2019 elections, which has been termed as the most expensive election ever anywhere, and as per the Center for Media Studies report, nearly rupees 60,000 crore was spent during the 2019 election. So we can see that huge expenditure is in electoral fundings. Then we have disrupts level playing field. You know, these it disrupts the level playing field. For example, few majority of political parties which are uh, major political parties, they get huge funds, and at the same time when smaller regional political parties or some independent candidate, there is no level playing field, to be in to be specific in simple words for them. If for example we will take some political party which is governing the state or which is governing the country, with respect the funding they are getting and the funds an independent candidate is getting, there is no competition in that. So it disrupts the level playing field, and the increased use of money power in the election, which also leads to the disruption of the level playing field. And what I mentioned, it uh, deters small political party and independent candidates. Then we have increased cash transactions. You know, whenever you have bulk of transactions in cash, there it leads to black money concept. It leads to corruption. So, as we know, electoral funding in the form of cash transactions is widespread in India, making it very difficult to trace the source of funds, increasing corruption and reducing transparency. And if you know that as per rules, political parties do not have to disclose all donations below 20,000 rupees. Then we have corporate and political parties nexus, which leads to huge corruption. It has been growing significantly, and और इसकी वजह से क्या होता है, political parties which are in power, they support a particular corporate, and you know and this leads to disruption of competition, which is natural competition in corporates. When you are supported by some political parties, when there is nexus, then it is by nature that you are going to excel as compared to the other corporate which has not funded that much to the governing party. So it disrupts the competition when this nexus is formed. Regarding electoral bonds, we had discussed it in our previous class also, but let us point out few important points in it. As we know, electoral bonds are interest-free bearer bonds or money instruments that can be purchased by companies and individuals in India from authorized branch of State Bank of India. It was announced in Union Budget 2017 and 2018. It can be sold in multiples of rupees 1,000, 10,000, 1 lakh, 10 lakh and rupees 1 crore. Purchased through a KYC compliant account, and there is no cap on the number of EVs that a person or company can purchase. So this might be asked in question about the cap on the EVs, as I had seen it recently in news. So for your information, you should know that there is no cap on number of EVs that a person or company can purchase. Then also available for purchase for a period of 10 days each in January, April, July and October. So let's see what is the way forward. One of the committee which we should know, that Indrajit Gupta committee, it suggests that state funding of elections should happen. That will lead the fair playing field for parties with less money. There should be transparency. Details of all donors should be made available for public scrutiny under RTI Act. There should be proactive disclosure from the banks, or we can say from Election Commission of India. Tax exemption should be to only those political parties who gain power or who win seats in Lok Sabha assembly elections. So also bring political party under the ambit of RTI, which we are about RTI, Right to Information Act. We will discuss that too after a few frames. Now let's move to its sub, which is about the electoral literacy. Before going to this topic, I want to generally we should ask ourselves a simple question: what is the problem? What is the main problem in our country, which is very degrading us in many ways? जो सबसे ज़्यादा problematic है, what is that concern, what is that problem in our country? If people will have different answers to this question. Few would say we have poverty, few would say our education system, blame our education system, few would blame our governance. They have different views regarding that, but what I personally feel that it is the हमें we don't have the knowledge about different platforms. It is one of the concern that we don't have knowledge about different platforms. We don't have knowledge about schemes. There are, government is doing enough to include everybody, but the problem is that people are not aware about it. Awareness is very low in our country about whether it would be about education, it would be about government schemes, it would be about healthcare, criterias, every stuff related to our life. Our awareness is very low. So similarly, let us discuss now electoral literacy. It basically deals about the sharing the knowledge of election or governance to the younger generation through school curriculums or through their subjects, making them aware about how it is done. So Election Commission signed an memorandum of understanding with the Ministry of Education to bring electoral literacy to classrooms across the country. So let us discuss about what are the salient features of Memorandum of Understanding on Electoral Literacy. It's systematically integrating voter education and electoral literacy into the curriculum of the students, starting from class 6th to 12th in all schools. Here, electoral literacy includes information on government, principal economic, social, and political issues that the nation is facing. What are the issues our nation is facing for social, economic, political? The value of democracy, equal rights of women and men, among others. Also, fosters a sense of responsibility with state education departments for establishing electoral literacy clubs in schools and colleges. Designate one of the rooms in every senior secondary school as the democracy room for regular display of voter education materials and conduct of continuous electoral and democracy education activities through the year. And also, one of the provision in this bill was NCRT will introduce and update textbooks to include content on electoral literacy, and will advise state education boards and other boards to follow suit. These are the salient features of the Memorandum of Understanding which was signed between Election Commission of India and the Ministry of Education. So let's move towards before going towards the way forward, we should know importance of electoral literacy. If we would, make it easy to understand, uh, I would say educate children about election process since childhood and importance of voting. You know, our children should be educated about the importance of voting and selection for selection of our representatives, and it will help in smooth conduction of elections in a diverse country like India. When our generations, younger generations, are aware about the selection elections, then it will help in smooth conduction of elections. Uh, it would address urban and youth apathy, leading to better electoral participation in general elections, and it would prepare future voters for ethical electoral participation and in efficient strengthening democracy. In like ours in efficient strengthening democracy, it will prepare future voters for ethical electoral participation. So, what is the way forward for that? Teachers should be trained, like organize seminars to be held by teachers, train them, show them how to transfer this knowledge to the children they are teaching. Then campaigns should be launched. Regular campaigns can be organized by the State Election Commission to enhance electoral literacy among the masses. Then we have increasing funding and coordinating with NGOs and Gram Sabhas to augment electoral literacy programs in the rural areas. If we know what are the initiatives taken by to promote electoral literacy, I would just name them. It is Systematic Voter Education and Electoral Participation (SWEEP) program. Systematic Voter Education and Electoral Participation (SWEEP) program is a flagship program of Election Commission of India for voter education, spreading voter awareness and promoting voter literacy. SWEEP program, you should know that it is the initiative for electoral literacy, flagship program of Election Commission of India. Then we have electoral literacy clubs. They were set up in institute campuses across countries by Election Commission of India under SWEEP campaign. So under this SWEEP campaign, we have electoral literacy clubs. So these are few initiatives. I would again repeat it, I forget to mention it here. Initiatives taken to promote electoral literacy, systematic voter education and electoral participation sweep program. Under it we have electoral literacy clubs. Then that is the next important, which is the most important of the articles which we have to discuss. It is about the role of a governor. You know, governor is the most hot topic forever in news. Usually different states, they are governing authorities, they don't get well with the governor. Same was the case with Kerala, Punjab and Tamil Nadu. They moved to Supreme Court against three respective governors over the pending of bills. They claim, for example, Kerala government has claimed inaction on the part of the governor uh, in relation to 8 bills passed by the assembly. Of these, some bills have been pending with the governor for more than 2 years. So there is huge inaction from the governor. And from Punjab, three money bills were withheld by Punjab governor, and similarly in Tamil Nadu petition mentions 12 bills are pending. So you would often see such news in day-to-day analysis. Daily, usually you would find that Falani governor is not going well with the Falani CM of the state. So let us discuss what are his financial in here. We would mainly discuss his financial powers of the governor. Let us go through it one by one. What are the, if we would start, what are the constitutional provisions regarding the powers of the governor? Provisions regarding bills. We have under Article 200, the assent of the governor is necessary for a bill to become a law. In this regard, the governor has been given some options. Either give assent, if he gives assent, bill will become law. Either withhold the assent, bill fails to become a law, or return the bill for reconsideration of the legislature as soon as possible. If this bill is returned, if the state legislature passes the bill in its original shape or in a modified form, the governor has to give the assent to re-enacted bill. He cannot withhold it again. He has to give the assent then if he returns it for passage. The constitution does not lay down any time limit, but here is a catch: as soon as possible. It doesn't. Constitution does not define it how soon. So this is what is mostly violated, I can say, by the governors uh, uh, in keeping with the bills, uh, withholding those bills, without say either without rejecting or sending them back. They are keeping it with themselves. Then we have another provision in it that reserve the bill for the consideration of the president, in which president can either give his assent or withhold the assent. President may direct the governor to return the bill to state legislature with his her message. Such bill, if re-enacted by the state legislature with or without amendment, is presented again to the president. Then he has to give the assent. Then we have what bills we have to reserve for the president. What bills uh, governor has reserved for the president. We have to discuss that. So in it we majorly found four things what governor can say. He can give the assent, he can withhold the assent or reject it, he can return the bill for reconsideration of the legislature as soon as possible, reserve the bill for the consideration of the for reserving the bill for the consideration of president. He There is a catch in it. It is obligatory only where the bill passed by the state legislature endangers the position of the state high court. This is mentioned particularly in the constitution. So in this case, he has to reserve it for the president. In addition, the governor can also reserve the bill if it is of the following nature: it is against the provisions of the constitution. If he thinks he can reserve it, it is opposed to the directive principle of the state policy. If according to governor any bill is against the directive principles of the state policy, he can reserve it for the president, or it is against the larger interest of the country, according to him, he can reserve it for the president, or it is dealing with the compulsory acquisition of the property. So these are the few main points which are discussed, that for regarding of which bills he can reserve for the president. If it endangers the position of the high court, it is mandatory for him to reserve, it is obligatory for him to reserve it, and rest are according to his uh, understanding. If any bill is against the constitution, if he feels that these are against the provisions of the constitution, then he can against the morality, he can reserve it. It opposes the direct principles of the state policy, against the larger interest of country, or dealing with compulsory acquisition of the property. Then we can see also the discretionary powers under article 1 section 3, which states that except when required to exercise his or her function in his discretion, the governor is bound by the aid and advice of the council of ministers, except where he is not needed to be to you know to regulate any bill or answer to any bill without his discretion. जहाँ भी इसकी discretion, where his discretion is not needed, so there he has to consult the council of ministers, and he is bound by the aid and advice of the council of ministers where his discretion is not needed. And where his discretion is needed, he can reserve it for the president or whatever. If president says him do it by yourself, if he feels that president is taking longer time on the bill, he can give his assent according to his discretion. So these are few judgments regarding role of governor. We have first S.R. Bommai, and in sorry, I did forget to mention it, Nibam Arabia case. In it, Supreme Court held that if a governor exercised his discretion beyond his jurisdiction of power, it would fall under the subject matter of judicial review. Under Nibam Arabia case, it was in 2016. So what are the recent judgments regarding role of governor? We have S.R. Bommai case 1994. The court held that the governor's power should be exercised in rare and exceptional circumstances, and that the subjective satisfaction of the governor should be open to judicial review. Then we have Shamsher Singh case 1974. Supreme Court held that governor does not exercise their discretionary powers while withholding assent or returning a bill to the state legislature. They are required to act as per the advice of the council of ministers. Then we have recent judgment, State of Punjab case 2023. In it, if a governor decides to withhold assent to a bill, then she has to return the bill to the legislature for reconsideration. Such bill cannot be kept with the governor indefinitely. If he, in this state of Punjab, if he withholds the assent, he has to return. He cannot keep it with himself for independent, for a longer, for a definite time. I would say indefinite time. He has to return it back to the legislature for reconsideration. He cannot keep it indefinitely with him. Then we have, and also with withholding assent or referring to the president, and that after exercising any of these options, whether he would withhold it or refer it to the president, when he exercises these options, he cannot then exercise another option again. Then we have Vice Chancellor case 2023. In it, SC underlined that the governor acting in their statutory capacity as university's vice chancellor are not bound by the aid and advice of the Council of Ministers uh, under vice chancellor's case. And then we had Tamil Nadu governor case. In it, SC stated that governor cannot refer the bills to the president after the assembly has reenacted the bills following the governor's declaration of withholding the assent. It is similar to the Punjab state of Punjab case. So these were few important cases which were needed to be discussed. This I feel that this vice chancellor's case, a statement may be based on this case, whether his discretion, where the advice of ministers is required there. I feel this might be asked. So I want you to go through these topics again, search in the books, and or just search these cases, these important cases regarding governor. You would get enough information, and whatever I provided, if you will keep that, that is enough for you. Then let us see what are the various issues concerning governor. We have pending decisions, delays in assent to legislations, and crucial appointments leads to a constitutional deadlock and disrupts parliamentary democracy. We have political interference from central government, as it can be well said as there have been instances where governors have been accused of political bias, especially in the case of government formation and use of discretionary powers. We have administrative inefficiency, friction between government and state government, especially where there is political difference, sometimes leads to deadlock in administrative decisions and appointments. We have burden on judiciary, and disputes arising from the governor's exercise of discretionary powers or their actions regularly leads to legal challenges and interpretations. वैसे भी हमारे यहाँ cases बहुत बड़े और इसकी वजह से they lead to the further burden on the judiciary. So let us go to the one more article. It is about special and local laws. Recently, if we know that criminal laws which were tabled for the reforming of the criminal laws, recently tabling of bills on criminal laws, it has kept special and local laws away from the ongoing reform process. So what is a special law? A special law is a law applicable to a particular subject covering special issues. For example, Unlawful Activities Act 1967, which we say UPA. Then a local law is a law applicable only to a particular part of India. For example, Maharashtra Control of Organized Crimes Act 1993. These laws were kept away from the reforms for criminal cases. Then we should know that cognizable offence is defined as the one in which an officer in charge of a police station may investigate without the order of a magistrate and effect arrests without warrant. So what is the significance of special local laws? We have high case of registration as per the crime in India statistics of 2021. Nearly 39.9% of all cognizable offences registered in 2021 were under these laws, special and local laws. Then we have efficiency in enforcement. Special laws enable law enforcement agencies to focus on particular type of criminal activities, allowing for more effective and specialized investigation and prosecution. For example, Narcotic Drugs and Psychotropic Substances Act 1985. Then we have protection of vulnerable groups. Some special laws are enacted to protect specific vulnerable groups such as children, women, and marginalized communities. We have technological advancement. Special laws can address crimes arising from technological advance, for example, cyber crimes. We have Information Technology Act in here. So What is the need for reforms in these special and local laws? We have unclear definition, ambiguous and vague definitions of offences and terms such as terrorist act, unlawful act, etc. We have applicability dilemma, the Protection of Children from Sexual Offences Act 2012. POSCO is increasingly being criticized for its applicability to consensual sexual activities between minors. Then we have clarity issues, concerns raised regarding categorization of matter falling under criminal or civil wrongdoings. We have dilution of due process. Then we have stringent provisions, for example, provided under UAPA, Narcotic Drugs and Psychotropic Substance Act makes the granting of bail and impossible. So this was about the special and local laws. I hope you understood it. What are special laws? These are the laws applicable to particular subject covering specific issues. For example, UAPA Act 1969. Then we have local laws particular to a specific part of the country. For example, Maharashtra Control of Organized Crimes Act. So in it we learned about significance of special and local laws, and we learned the need for reform. Then we have Right to Information Act. This is one of the important and mostly found in news. Here, let's start with the Supreme Court directed the center and the state governments to fill the vacancies in the Central Information Commission and State Information Commissions. There are huge vacancies since long, and Supreme Court directed central government and state government to fill these vacancies. And SC also stated, Supreme Court also stated that non-fulfillment of these vacancies will make the Right to Information Act 2005 as a dead letter. So there is no value to this act if these vacancies are not fulfilled. Let us see about Right to Information Act. And that what does it comply to us? What does it say to us? Any Indian citizen can request any information for offences from offices and departments of state or central government. We should know that it is not any information. If it is about security, we cannot ask central government how to make a bomb or how to do different stuff. So there are some limits to it, which are classified in different schedules. For example, Schedule 8 in of this act, we have without information, freedom of speech cannot be fully used, as mentioned by Supreme Court. And this Right to Information Act, it replaces the Freedom of Information Act 2002, and its nodal agency responsible for implementing the Right to Information Act is Department of Personnel and Training, and DOPT, under Ministry of Personnel, Public Grievance and Pensions. So UPSC usually asks questions related to these lines, which is the nodal agency for this or that. So we should know the nodal agency for implementing the RTI Act is Department of Personnel and Training, DOPT, under Ministry of Personnel, Public Grievance and Pension. So what are the key provisions of RTI Act 2005? In it we have section 2H. It is about public authority, means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, state legislature, by notification issued or order made by the appropriate government, and includes any body owned, controlled, or substantially financed non-government organizations substantially financed directly or indirectly by funds provided by the appropriate governments. So it defines what public authority is, whether they are government or non-government, financed by government or not financed by the government. So it defines everything in it. Then we have section 41B. It lays down information which should be disclosed by public authorities on suo motu, on their own proactive basis. Then we have section 6.1. A person who desires to obtain any information shall make a request in writing or through electronic means to the Central Public Information Officer, Central Public or State Public Information Officer. If a person wants to know the information, he has to write to him, ask for the permission. Then we have section 7 fixes the time limit for providing information by public information officer, within how long this information will be provided. Then we have section 8. It gives the exceptions from disclosure of information. We have exemptions under RTI Act 2005. Recently, as we know, the central government through DOPT issued a notification under section 24(2) of RTI Act 2005 to exempt Indian Computer Emergency Response Team (CRTIN) from purview of RTI Act and added CRT in second schedule of RTI Act. So CRTIN it is not in it. Then we have section 24 of the RTI Act, which says that this law is not applicable to the intelligence and security organizations specified in second schedule. However, information pertaining to allegation of corruption and human rights violation shall not be excluded of those security and intelligence agencies. Then other exemptions under RTI Act 2005 are information disclosure of which would affect sovereignty and integrity of India, on economic interests of state. We have contempt of court, breach of privileges of parliament or state legislatures, commercial confidence, trade secrets or intellectual properties, useless competent authority is satisfied unless so while all these, it is it is very well established in our mind what would be. It is very much basic and very ये हमें खुद ही पता होगा कि हमें कौन सी इंफॉर्मेशन दी जाएगी which is essential for the government, which in which government is highly involved, security is involved, economic function is involved, or anything else, intelligence is involved, that won't be provided to us. So section 8 deals with it. If a question might be asked, RTI Act 2005 section 8 deals with what, section 7 deals with what, section 6(1), these are important provisions in it, we should know that. Section 2, it deals with public authority, which is the public authority. Section 4, it deals with information which should be disclosed by public authority. So such questions would be asked. So let's move to our next. What are the concerns in it? We have poor record keeping. If our RTI applicants have been denied information due to factors like lack of records are not in a proper format or have gone missing. Then we have lack of infrastructure and stuff, huge pendency and delays, threat and violence, lack of awareness, as this very much understood by its headings only. So let's move to our last topic of today's discussion. It is about Bihar cabinet, which passed a resolution requesting the center to grant special category status to Bihar, and it cited following reasons: poverty and backwardness of the state. And it said that after the bifurcation of state when Jharkhand was created, majority of the industries went to that part and we lagged very much behind. So what are special category status? It was classification granted by the center to assist the development of states that faced geographical or socio-economic disadvantages. It was introduced in 1969 under recommendation of Fifth Finance Commission, and state special category status used to receive grants based off Gadgil-Mukherjee formula. And constitution does not include any provisions for categorization of any state in India as SCS state. There is no provision mentioned in the constitution. A state should have following provisions, then it should be included in the SCS. It was introduced by the 15th Finance Commission. And what are the benefits of central assistance? This is the Earlier, the Gadgil-Mukherjee formula earmarked nearly 30% of the total central assessment for status to the SCS states. However, 15th finance recommendation led to this allocation being merged into increased divisible pool funds for a status, rising to 41% in 15th Finance Commission. We have funding benefits in the 60 to 40 for and 90 to 10 for special category states and general states 90 as grant and 10 as loan, which they have to pay back, and for other 60 as grant and 40 as loan. Then we have continuity of unspent money. For example, if in its special category status had the facility that if they have unspent money in a financial year, it does not lapse. Usually it lapses if they have unspent money, but for them it does not lapse and can be and and gets forwarded to the next year. Then incentives, several incentives are available for them for concessions in customs and excise duties. But in 2000 in 14th Finance Commission, this special category states have ceased to exist. So you should know about that. This was about our discussion about these topics. So I hope I was able to provide it very well, and I hope you would have gained information from it. So keep watching these videos. As I always say that maybe my way of teaching might not be beneficial to you, but the information here given is very much important. If you would understand it and if you would start working on it, you still have 2 months for your UPSC exam. Just go through these. Now your strategy should be different. When a serious aspirant is working, he is very serious in his studies. Till now he has done many revisions. Now what he has to do, he would go through the current affairs, he would go through the test series and what questions are asked or what were the topics in news, and he would revise those topics only to save his time and to increase his grip in this exam. So I hope you would do it. I hope this would be very much beneficial for you, and my best wishes for you. Take care and have a good year from for you all, guys. Thank you very much. If you had watched, thank you very much for watching this video. This is very uh, important, and I want to tell you one thing, that this takes huge effort to make these videos and to search for the information. I hope if you are watching this you would like this initiative and you would share it with your friends. Thank you very much. Take care.